Hello, everyone. Welcome to the webinar. I will leave maybe 1 more minute for the other participants to join. In the meantime, you can see already our screen, the topic of today's webinar. Okay, I will then go ahead and we will start the webinar. So welcome, like I mentioned, to the second edition of the webinar series on intellectual property essential, which is part of the iPower SMEs initiatives, which is a series that aims to bring together SMEs, especially those in the digital sector, but not only, and experts that are working in the area of intellectual property rights, to share about their experiences and to give advice to those SMEs that are seeking to navigate the intellectual property landscape. So if you want to learn more about our first webinar on the topic of strategies for business growth and innovation, I will share briefly the link to the recording and all the information that were shared during the webinar. But for this second edition, we will discuss about leveraging IP assets for SMEs financing opportunities. And I have with me 3 professionals that are working in the sector from different areas of application. So I'm positive that their expertise will offer interesting insights on this subject. So please allow me to introduce the experts of today's session. Aushra Pakiniene is the head of Trademark and Design Division at AAA Law. Here, she specialized in the field of intellectual property protection, advised clients on various intellectual property issues, registered trademarks and designs in Lithuania, in the EU, and internationally. Then we have also Felix Yuen from Fruba Consulting. He's an experienced IP lawyer and advisor specializing in IP commercialization. He supports SMEs and startups in developing and realizing their intellectual property initiatives. And finally, we also have Juan Luis Rodriguez. He's a lawyer working with RTDS Group. As an IP expert, he has coached European SMEs in the development of their IP protection strategies through services such as Horizon IP Scan, European Innovation Council, and SME Executive Agency of the European Commission. Like I mentioned, our discussion today will have the format of a question and answer session, and you already shared your questions for the experts in the registration form. So we will address those questions that are linked to the topic of finance, but we also receive questions that are linked to more general IP topics, which we will address during our next webinar, where we will present the IP guidelines for SMEs that we are currently working on, and I will share about this webinar a bit later. So very quickly, to set the scene of today's discussion, we selected the topic of finance for SME, for this SME's IP Essential series, as over the last decade, intellectual property assets have increasingly contributed to the market value of companies, including SMEs. This has primarily been driven by the emergence of a new economy known as knowledge economy or data economy, in which the core capital of companies takes the form of intangible assets such as patents, processes, know-how, customer reach, data, or workforce talents, rather than physical assets. While some countries are currently paving the way for a better environment, favoring the use of IP as access to funding for SMEs, day-to-day practice is still at a very early stage. So most of them, some of the most common challenges that are encountered by SMEs are that IP is difficult to value and even harder to monetize, and often requires a specific case-by-case analysis for proper valuation. And IP is often regarded as having low to no capital rating for lending institutions. IP is still used as component added to the lending package rather than as the primary asset. So to start our discussion, we will build on what we learned during our last webinar, when we discussed how SMEs can define their IP portfolio. And we will look at the financial support available to SMEs for various IP-related activities. So I would like to ask Aushra to present the EU IPO SME Fund, and also if she has any maybe practical experiences from Lithuania to share with us.
Hello, I will share my screen and my slides. Do you see them?
We see them.
Okay. So I will tell you about the SME fund, which is organized, initiated by European Commission and which is implemented by European Union Intellectual Property Office. This project continues already for the third year. It is a grant scheme for supporting registration of intellectual property rights. And for this year, budget of this project is 20 million euros, and project continues from January 22, and it should continue until December. But as I know, the funds are coming to an end, and it may end even in July or in August, because SMEs actively use this project for registration of their IP rights. And there are four IP objects which could be supported. It is IP scan. It is a service for pre-diagnostic of intellectual property assets held by SMEs, and private external providers or national IP offices can provide this service to SMEs and help to better understand value of intellectual property for business, its commercialization, and to identify assets which could be registered. And it is quite a good scheme, because you can compensate 90% of fee for this service. Of course, every country has some ceiling and some amount which cannot be over increased by the company. And also you can get a compensation for registration of your trademarks or designs, and for national rights and European Union trademarks and designs, you can get 75% of compensation of the official fee for filing and registration of trademarks and designs. For international registration, you can get up to 50%. It is very good opportunity to get compensation for patents, and this year we have not only national patents support for national patents, but also for European patent applications, and you can get 75% of compensation for the official fees for search, for examination, and patent application. So this year we also have support for legal services, which means you can get some compensation of services for drafting your patent applications. So it is very good opportunity for companies. And this, yes?
Sorry to interrupt, but I think now we see the presenter view of the slides. Can you put them in full presentation mode?
Mm.
Yeah, perhaps you just need to change the screen.
And I don't know how to change my screen. Sorry.
If you don't manage, don't worry. We will share the slides after the presentation. We can see it, but it would be maybe more easy to see it in full screen. But if you don't manage, no problem. We will share the slides afterwards.
It will take some time. Maybe you can live
Yes.
with this presentation. Sorry, but my technical skills are not very good in this
Yes, no
time.
worries.
So, and regarding support for patents, this voucher is stopped for the moment, but I know that it should again begin in the middle of May. So there is still possibility for SMEs to get support for patent applications and registration. The fourth voucher could be obtained for plant variety rights. You can register plant varieties and get 75% of the official fee. And the scheme works in such a way that you have to file application for support, get a grant decision. You can get a decision in 2 weeks, and after decision date within 2 months, which can be extendable up to 4 months, you have to file for registration your IP right. And when the trademark design or patent is applied for registration, you can ask for the compensation, and usually compensation is paid within one month period from filing this request. So the scheme works very smoothly. SMEs are very actively using this project, and for example, in Lithuania, we had 961 application in 2022, 1,100 in 2023, and this year, in 4 months, we already received 537 applications. So it shows that SMEs are very interested in this project. And who can apply? You can see on the screen what size enterprises are entitled to receive a support. It is micro, small, and medium size, and it is calculated by number of employees, by turnover of the company, and balance. So you will get slides, so you can see in details what companies are entitled, and only essentially if SMEs are filing this request themselves, they need only 2 documents, which is VAT certificate or extract of company's registration from commercial register or enterprise register, and company's bank statement in order to transfer compensation to the company's bank account. And if a representative is involved in filing this request, you have to sign declaration for representative so that the representative could file this request. And the process is very simple, as I told you. You can see it in pictures. You have to apply to receive a grant decision, to request for registration of your IP right, and get a compensation. So That is full skim. Thank you. And I will stop sharing my slides.
Thank you. Thank you very much, Oshra. I'm happy to hear about this funding opportunity, and also happy to hear that SMEs are applying for these funds. And I would maybe like to ask Felix and Juan Luis if they are aware of other subsidies or public grants in their countries or their region.
So yeah, perhaps it's not a direct funding scheme like the SME fund, but if you apply to a grant of the Horizon Europe projects, right? If you apply it to, if you're getting involved in any of these research and development projects funded under this framework program, you could, as an SME, make the eligible the cost for the registration of the intellectual property rights that you need to protect the result of these projects. You can charge it to the project. Basically, they are eligible costs to the project, and also it's very important that what Aura just mentioned also, the IP scan, right? One thing is just the registration cost, right, to get the reimbursement of the registration fees, but also it's very important that SMEs get the valuable support, expert support on the elaboration of the strategy. You know, I think this is very important. How to maintain the portfolio, how to identify the protectable subject matters. You know, these aspects are very important, and for that, I think it's very valuable that the European Commission at least has all these services available for with experts that can guide SME owners on that.
Right. I'm also jumping a little bit here. Well, now when we talk about funding of having IP, we're talking about the first part of it. We're getting funding for obtaining IP rights. I know we are going to talk about how to leverage the existing IP rights to get more funding. There'll be the later topics that I think Luis and Asra will deal with it. And indeed, apart from the EU perspective, different countries will have their own projects and also campaigns in pushing for getting IP rights for SMEs and also for their own local companies. I'll give a few examples for the markets that I'm more familiar with. For example, in Ireland, which is very innovation focused. Enterprise Ireland in Ireland, which is the Irish government agency, they do have a lot of programs that would help their local companies, for example, not only just on IP, but on IPO digitalization, going green, all these initiatives. They would provide certain grant for these companies. In relation to IP rights, of course, I can also distinguish into two sides of things. There are those that particularly in relation to the IP rights, that is similar to SME fund. For example, they have two programs called the IP Start and IP Plus, which is for them to get the IP expertise service, for them to have the strategies and also to cover the costs in applying for these IP patents, trademarks, design, so on. That is one side of things. And of course, IP has to have a basis. IP right is only a tool. It has to have a creation at first to protect before we talk about the IP rights. And also, of course, there are campaigns and programs that will help these companies to innovate and create. In Ireland, for example, they have several programs. Some of them are actually overlapping, and it depends on what the companies would need, and depending on conditions. Giving two examples, one of them is the research, development, and innovation funding, which is for the companies to get funding for their own internal in-house development of ideas. These funding will help them to generate more expertise for their internal R&D for the new products and services covering, for example, industrial research, experimental development on new product, process, use of new technology. New technology would cover use of blockchain, AI, for example. This is on one side of things. And on the other side, some funding will also allow them to cooperate with external programs. For example, the research institutes, they call that knowledge partners in Ireland, so that these research institutes would do the part of the development and production of these the IP. And then this company can benefit from licensing from these results. I have the benefit of seeing the questions provided by our participants. I see one of them asking or questioning on why the research institutes would own the IP instead of the company who get the grant. This is a very interesting question because it's also important for as an IP strategy too, as a company, in choosing which grant you would go for. For this type of grant, that you would seek government funding on to work with the research institute to create IP and product. Normally, and I would say it's not uncommon that the institute would get IP. The arguments from them would normally be like, well, first of all, this is public funding, so they would like to have it not only just focus on one commercial entity, but for the general benefit for community in general. And then secondly, they would also need to see how the research institutes can benefit from it, from all these fundings, from all these commercialization, and to make sure the continuity and sustainability of the research institutes, and also to incentivize more researchers in helping companies in developing the new ideas and products. So that is the reason why some IP would, in some situations, in some programs, the IP would be transferred to the research institutes instead. But of course, the good thing is that, well, for example, in Ireland, there are different programs, and if the company would like to have more control of the IP itself, there was the one that I was talking about on research development innovation funding, which would mean that everything is built in-house. You can determine how the IP is going to be like. This is the situation in Ireland, and for example, also in Malta, there are very similar programs, and I believe that in other countries in the EU, they have very, very similar programs too. And I can't really go into every single part of it. And after this call, if any participant interested, feel free to connect any of us, and then we can point you to the right expert to tell you more about the local situation.
Thank you so much, Felix. I also confirm that in Belgium there are similar initiatives of the different regions in Belgium. So if there are companies in the audience interested, I will later share a link there that they can have a look at. Okay, so now we looked at the way SMEs can fund their IP assets to start with. But then most activities that are related to planning, to negotiating, managing business relationships require information on the value of the IP assets of a company. So the valuation of any type of asset, including IP assets, it helps the owner decide what is the most cost-effective way in which that asset may be used, protected, insured, sold, leveraged, or exchanged in the marketplace. I would like to ask maybe Felix, if you can give us an overview of the main valuation methods applicable to SMEs, and if you have any practical examples, that would be very useful as well.
Sure. Maybe before I jump into the valuation method, I would first explain why IP valuation is important, the reason why we do it. It's because, well, from different perspectives, of course, internally, you will need to know, you will want to understand how your different IPs, different sectors are important to your company, so that you can make your own decision as to which one to keep and which one to invest. It's quite important for internal financial management and also in general product management perspective. But from the commercialization perspective, IP valuation is even more important because you have to convey these information to third parties, to the one who would be interested in your IP or in your product. First, you would like to have this valuation because you want to have a very better pricing of your product or pricing of your IP. The valuation will help you in the royalty calculation to determine at least it is not under the market value, that what you can get at least from the market. And secondly, of course, when it comes to financing, when it comes to transaction, external parties would like to understand like what your IP, where you say you have your creative ideas, you have innovation, but what does that mean to me? We're paying consideration for that. How much should I pay for your transaction, your finance? Or how much should I use it as a collateral? How I should value to use it as a collateral? These parties, these banks, these partners would like to understand the exact or objective way of calculation of the value of the IP. And of course, in some situations, which is less likely, but we also see a lot of situations coming up with damages when you see IP infringement and it goes to court, arbitration, or dispute resolution. Often the case you are looking for the other party to compensate on the damages when they infringe your IP. And damages is in a lot of cases based on the market rate, which is how much you can license it to someone else. And if that's not possible, then they would be using other methods. And now we come into the different methods on evaluating IP. I have to be a little bit general here because, of course, when we talk about IP, there are so many different types of IP, and different type of IP would have require different methods to deal with. In general, usually we will say there are three types. There are the cost method, market method, income method. Cost method is basically to look at how much you need to spend to develop the same product, or how much you spend to get a similar product from outside. This is particularly useful when your technology, your IP, is not comparable in the market. There's no information out there that you can compare. You won't be able to say, oh, the A company licensed it for a certain amount of money. Or if this current technology or IP doesn't really generate income, there's no quantitative value in it, then cost method will be interesting, especially for the other side, because normally the cost method would be the more conservative outcome compared to the three different methods. But of course, the problem of cost method is that it doesn't really take into account the uniqueness of the product of the IP, which means, we all know that we have this IP because it's different, it's unique, it's not the same as anyone else. Cost method doesn't really take into that margin or the edge of it. So that is the bad side of cost method. And we have market method, which is very commonly used. Basically, it's a comparison of different products in the market, and you'll find a most similar one and say, okay, probably this would be the value of your the IP2, because outside in the market they value it as much. The good thing is, of course, it is more transparent if there is the data out there, and if there is active market, it will be very useful. But also there is a situation where there is no market for certain product. If your innovation is so out of the world, that is so new, so creative that no one has ever thought about it, then there will be no market to compare to. And also, of course, market method would again not consider the special and uniqueness of your IP. That would bring it even higher, the value higher than the market general. So that's why there is this third method, which is called income method. Income method calculates how your IP, how much your IP can generate in the future. The mostly used method would be called the discounted cash flow method, which is basically taking into the price and sales that you can generate in a certain time period. If it's, for example, patent, of course, it will be the lifetime of the patent. And then it will apply on a discount rate to it, which would take into account all the risk involved in this the future. The risk would be, for example, legal risk, market risk, competition risk, so on. And then the income method is very useful when your product is already out there, it's already generating income, and you see cash flow from it. But then because of we're talking about years to come in the future, there would be a lot of assumptions that we have to put in place in there. Even if there is a discount rate which already takes into account the risk, there's still assumption that involves a little bit of subjectivity in it. So that is the idea of the three methods of valuation. And in the end, in a lot of situations, people actually combine one or more of these methods to put it into real use, because it really depends on the goal and needs of that particular valuation. And also it would depend on the stage of your IP. If you're at a very early stage and you just have an idea, when you don't have a market and you don't have income to consider, then the cost method would be more appropriate. Otherwise, if you're at a later stage when you're already out in market and you're strong in your IP in your product already, then of course the income method or the market method would be more suitable.
Thank you so much, Felix, for this great overview. And indeed, I think SMEs must consider different aspects when they're doing the valuation of their IP assets. So now I would like to go to another question linked to this. What is the role of valuation when SMEs are looking to access finance for business growth or operation? Can IP be used as collateral for debt financing or even equity financing? So I wonder if Ausra, would you like to take this question and maybe also provide some example from your practice?
Yes. Yes, it can be used, and you can use your IP right for licensing and obtaining some royalties from this license. You can, if your IP right already has value, you can pledge it with the mortgage institutions, and so you can get credit from bank institution and pledge your trademarks, designs, and patents, and get credit for further development of your technologies. And it is possible to register this pledge with the national offices, and usually you can see the trademarks or patents which are pledged in official database of trademarks and patents, which is available online. So I think a lot of companies use this possibility, because I can see in our practice, when I look through database, when I am searching some trademarks, you can usually notice some trademarks which were pledged, which means that SMEs and other companies are using this financial method.
Indeed, but since there is no, let's say, common practice across European countries, I think it's up to each individual SME to see with their institutions, lending institutions, bank, etc., what are the conditions under which they can apply for funding using their IP portfolio. Thank you very much for this, Ausra. And I will then go on to another question that we received from the audience, which is more linked to the topic of due diligence. So one participant asks, with the different know your client, know your business rules in all EU member states, do you think IPR marketplace is feasible under the current non-standardized rule in that aspect across the EU? So I would like to maybe ask Juan Luis if he can give us his perspective on this matter.
Oh, well, very specific question. Great. But if I may, I will simplify the question a little bit because, yeah, in the spirit of this workshop, no, I think just to simplify it in a very easy way, I would say, what is the importance of due diligence, right? And I think this is the main thing before we talk about the IPR marketplace. I would say the due diligence is important for three main things, I would say, um, in my opinion, right? Ownership, documentation of what are the ongoing transactions around the intellectual property that we're using for the negotiation, right? And enforcement and enforceability. So ownership, do we negotiate rights with the right person? It happens a lot also in research projects that I'm managing, that we get organizations that come and say, well, I have this patent. And the reality is when you do a basic search in public databases, you realize that the owner of the patent is not the person that comes and saying that is the owner, right? Or that will provide this patent for the implementation of the project and so on. Same happens in terms of commercialization or when you are looking for investments. You can see that actually is a very important and ongoing topic. You know, this company OpenAI and all the what is happening now with the New York Times doing OpenAI because copyright infringement. Did they knew that they were unauthorized to use the data from the New York Times and so on? So this is a very important topic at the moment. Who owns the data, the intellectual property? In terms of documentation, it's very important to see when you enter in a negotiation or when you are claiming investment or applying to get some investment, of course. If there are any licenses, if on that technology, on that thing that you have protected, perhaps in a patent, who owns the not just who owns it, but where or who has access exploitation rights, right? Or where are these exploitation rights distributed? I think this is very important topic because based on the numbers of people that have exclusive licenses, and the value of the intellectual property may be also affected. What happens if one of your competitors has already a license for a specific market? Then you might be restrained, no? And then you see a little bit of a picture on that on the documentation, but also the enforcement is also very important. To me, things that I've seen is, well, people tend to imagine that because you get a patent in Europe, and well, now we have the unitary patent, but that if you get a patent in Europe, you get another one in United States that automatically gives you the right to enforce this patent in other countries, let's say Brazil or China. You know? So we all know that intellectual property rights are granted by a national or regional authority in this case. Therefore, if you don't have this intellectual property right register acknowledged officially in the countries where you will exploit that technology, then you might have problems in doing the enforcement, right? So my point is, well, if I'm going to have a negotiation and I'm considering the exploitation of that technology in Brazil, I need to make sure that whoever owns the technology, the intellectual property right, has also the rights in that country where I need the technology to for the production and so on. And this is also, of course, depends on the type of intellectual property rights, right? So we have, for instance, easy ones that we can check in open access databases like or public access, like those intellectual property rights that are registered, patent, trademark, industrial design, even plant varieties, it was mentioned already. But then what happens when you have others are secret, you know, the famous trade secrets. And today, or common examples of trade secrets is not just referring to the traditional Coca-Cola recipe or the McDonald's sauce recipe. Today is also referring to data sets, you know, the databases. And again, some of the issues we're now facing with the launching of the AI tools, no? So in that case, then you will have, if you need to make a negotiation with someone that has this kind of intellectual property right, you will need to get an additional clarification. For instance, well, if you have some data and it's confidential, where is it located? Where's the data stored? Then you will refer to some terms and conditions upon which people can access these data sets, and you can request, let's say, maybe who is the authorized people, what are the confidentiality measures, and so on. No, I think this is the issue when you try to clarify some questions before you negotiate with the IP owner. No? That needs to be clarified in the due diligence. And then when it comes to the marketplace, I think that there are, of course, several challenges. I think this is part of another discussion, because I don't know if you can actually standardize all these ways to implement due diligence across. I think that there are basic informations or boxes to tick when you're doing IP-related due diligence. But now, for instance, we see that there are some tools, blockchain technology, for instance, that maybe perhaps will simplify the way we identified the acknowledgement of who is the actual owner and what is the field of use, and all these aspects around that can affect the exploitability of the intellectual property.
Thank you very much, Juan Luis. And indeed, although this matter seems quite complex, it is very important. Due diligence is very important, both for your business operation in time, but also it can affect your chances of having access to the different types of financing. So now I will go to our next question. So once the value of the IP assets has been determined, the next step for the companies is to consider how to monetize them. So one question we received is, what are the most effective strategies for turning IP assets into sources of income for my company? And what legal considerations should I keep in mind when monetizing my IP assets? So can you please give us an overview of what kind of IP commercialization strategies SMEs can apply? So maybe I will start again with you, Felix, and then I will also invite Juan Luis to give us his perspective.
Thank you, Loida. Thank you for the question. Again, this is a very general question that I'd love to go into the details of it, but now because of the time, because of the generality, I would stick to the more high-level strategies that I always remind our clients and even myself as a SME myself to think of when it comes to IP. First of all, I think the ultimate question is what value it is in your IP. What do you think your business or product actually brings value to you? And this would come back to the question of why we need IP scan in the beginning when we talk about this funding from the EU and from the independent countries, because we have to know what actually is in our book that we can use of. And we need to see how we make use of this particular strength of your product and IP on top of the others. And then you need to see if you can describe this IP in a very easy, simple way to others. If you have problems in summarize your ideas or generation or innovation in a few sentences or in a page, then you need to really sit down and formalize it and document this IP in a one-page document to say what it is, what benefit it can bring, what value it can bring to your company. And also very important to understand the nature of the IP too. Juan Luis mentioned the situation of an open AI, if the value, your IP actually relies on third parties or relying on external partners, external sources, then you need to have different strategies. So you need to get, first of all, what the IP is, what the value is. And then we will come to the second stage, which is to also understand the strength you have as a company and how much control and how much work that you want to do in relation to this IP. If you are at the stage of a very early beginning stage, you only have a very good idea, you don't know how to do research and how to develop it, then your strength is basically to formalize idea and then to work with, for example, different research institutes to bring it into practice. That could be one example. Or another example, if your strength is actually to develop a prototype, successful product, you just need someone to market it to different sectors. Then at this stage, your strategy would be looking into finding distribution channels and distribution partners that have this particular specialties in bringing into different sectors. And another example, if you're good at everything, you have a stronger company that has established a very good basis. You have very good business ideas, you have good products with all the things I mentioned before. Then you can focus on bringing in a good licensing strategy and licensing platform so that people can come to find you and you make visibility of your products and IP so that people can already know where you are and find your product and IP. So that is the second stage. Think of the strength of your company and the control that you want to put on to your IP. And then the next stage would be prepare the groundwork before you actually commercialize it. The groundwork, of course, would be the legal considerations. You need to have IP protection. Well, if it is the something that is going to be copied, of course, you have to have patent protection so that you have exclusivity or design protection or trademark protection. Something that you can tell people that, well, I have an asset here, no one else is going to make use of it except for myself, so that your licensee or your buyer can be assured that the value actually stays in your IP. And then, of course, it will also depend on, very importantly, the contracts that you're going to formulate with your partners and your licensees or even your suppliers, because IP there, especially the most important clause that I think is the IP clause that would define the ownership of it, what foreground, background IP, who owns which part of the IP, and you have to make very clear definition of that, not just having a legal definition of pre-existing IP versus new IP developed. You have to actually name in what situation that IP falls into which side. And then you have to have a very detailed license scope and a royalty basis so that people will not dispute later, your partners will not dispute later on how much they can get or you can get. And of course, contract also includes a very important confidentiality clause, which is the utmost important in for a lot of IPs, for example, trade secrets or even designs and patents when you are not supposed to disclose it until you file it. So these are the legal considerations that you should have. And finally, with all these considerations, the last step would to be select the right commercialization models. It would depend on how strong your IP is in terms of exclusivity. If you have a patent in hand, already filed a patent, then obviously you can make better use of it in excluding others, and you have a less concern on getting it quickly out in the market because people may copy it. On the other hand, if your model, if your IP is actually, for example, a technology, a software platform, a SaaS model, it is of course you own the copyright in the codes, but also the idea you cannot prevent the ideas being copied by others or imitated by others. In that situation, perhaps your right commercialization model would be to go to the market as quick as possible and get the right market share, and then at the same time build in services that would bring more value to it. The services also involves IP. That would be your own knowledge, your own know-how that only you can bring into your product. So different strategies for different IP model, and then you will have to also consider whether you want exclusivity, non-exclusivity, and then the market demand. You also look at the market demand and see whether you need to partner up with different strategies to go into different sectors. So these are my few points. I'll ask my fellow panelists to add on to that.
Yeah, no, perfect answer. But look, I will also include maybe in the negotiation, okay, whether it's licensing or even the let's say when you enter in a research project as well in collaboration, there are, for instance, issues about the cost, of maintenance or enforcement of the intellectual property that you should also consider. The duration of this negotiation or the licensing is very important as well, because that can also or the intellectual property, as Felix was saying, that you have a patent, but you know that a patent expires in 2 years. Doesn't make any sense that we invest a lot of money when this patent will be out in the public domain in 2 years. These are things that should be taken into account when you're thinking about the negotiation of intellectual, any of the method for monetize intellectual property. Yeah, I would just stop here because I think we're running out of time as well.
Thank you very much, Juan Luis. Indeed, we're almost at the end of our webinar, so I'm afraid I will not be able to take any more questions because I would like to share with you some information about our next activities. So, but first of all, I would like to thank all of you for your participation and for sharing your experiences with us. To the participants, but also to the experts that were here with us today for their advice. If you wish to stay in touch with any of them, you can find them either on LinkedIn or our event webpage. So in the meantime, I would like to share what are the next activities of iPower SME initiative. Namely, on the 11th of June, we will organize a third webinar. We will discuss IP issues specific to digital SMEs. We will touch upon topics that were mentioned already: artificial intelligence, cybersecurity, technology transfer, and so on. So please feel free to join and send your questions in advance to the experts that will participate. Also, if you wish to contribute yourself to the knowledge ecosystem for SMEs regarding IP, we have an ongoing call for best practices to share insights and strategies that have proven effective in the area of intellectual property. And finally, if you yourself offer support services or legal advice to SMEs, I would like to invite you to register your contact on the stakeholders map, which is a list that we put together with potential collaborators in IPR support services at national level for SMEs to connect and have access to a series of support services that are tailored to their needs. Before I close the webinar, I would really appreciate if you could give us your feedback on the discussion today by answering the poll questions that we will open right now. It will be very useful for us to understand if the discussions we had today was interesting for you. So there are only 2 questions. So here we have question 1, which is open. I would suggest we keep it open for another minute. And then we will go to the second question, which is mainly about the country from where you are watching us and where you are having your activity. So I would say we close this question. Then we open question 2. Okay, then I would say we can close the webinar here. Thank you so much. We will add the recording and all the information that was shared during this webinar on the event page, and then we will follow up with an email so you know where to find all this information. Thank you very much again, and I hope to see you at our next webinar.
Thank you. Bye-bye.
Thank
Thank you very
you.
much.
Bye.